Good morning. A fantastic judgment delivered by the Supreme Court because day to day the defense lawyers, public prosecutors, the appellate advocates used to come across the one question whether the allegations contained in the FIR or charge sheet is sufficient to proceed for offences under section 409, 420, 477A. Here, the Supreme Court now well settled this law, a multi number of pages of judgment. Here, actually, what had happened, the bank officials seems to have helped some third party by providing some loose check sheets, and subsequently the amount was settled properly, but they were prosecuted for offences under section 409, 420, 477A. Then you see the necessary ingredients. They say breach of trust, cheating, falsification of account. Accused branch manager of bank allegedly misused his official position and passed 3 loose check leaves to co-accused despite insufficient funds in his said account and caused wrongful loss to bank. Issuance of loose leaf check is departure from standard operating procedure followed at bank. No evidence that it was illegal practice. Witness, chairman of bank and auditor stating that in ordinary course of business, check holder ought to only utilize check that are issued to him, but certain contingency bank can issue loose leaf checks also. Since no explicit prohibition on issuing loose leaf checks, mere fact that accused issued these checks, it cannot be said that he acted unlawfully and committed criminal misconduct. No evidence that accused gained any pecuniary benefit. No pecuniary loss caused to individual or to any other bank. Prosecution failed to establish that there was any criminal breach of trust against the accused beyond all reasonable doubt. Then they say criminal 409. 409 is probably all the cases filed against government servant as well as politicians. Ingredients: entrustment of public property and dishonest misappropriation or use thereof in manner illustrated under section 405 are sine qua non for making offence punishable under section 409. They say 415 is a definition clause wherein criminal breach of trust is defined. So that consequently follows 409. That was the Supreme Court said. Then they say 420. It is paramount that in order to attract the provision of section 420, the prosecution has not only proved the accused has cheated someone, but also that by doing so, he has dishonestly induced the person who is cheated to deliver property. There are thus 3 components of this offence: deception of any person, fraudulently or dishonestly inducing that person to deliver any property, mens rea of accused at the time of making inducement. These all are the most important. Then finally they come 477A. In an accusation under section 477A, the prosecution must prove that the accused destroyed, altered, mutilated or falsified the books, electronic records, papers, writing, valuable security or account in question. The accused did not so in his capacity as a clerk, officer, servant, or employee. The books, papers, or belongings to or any person of his employer had been received by him for on behalf of his employer. The accused did it willfully with intent to defraud. This is what most important. Finally, the Supreme Court punished him in a different way. They say, we face no difficulty in holding that the prosecution has failed to prove the charges under section 409, 420, 477 against the appellant beyond reasonable. As necessary corollary thereto, his conviction under Section 13(2) read with Section 13(1)(d) of PC Act can also not sustain. However, the benefit of doubt being extended to him on account of thin margin between strong suspicion and conclusive proof shall not entitle him to initiate a second round of his list to seek his reinstatement or to claim other service benefits from the bank. We have already held that appellant is deemed to be guilty of gross departmental misconduct, for which punishment of dismissal from service has been adequately awarded. It requires no repetition that standard of proof to establish a misconduct is a domestic inquiry. Even preponderance of evidence is drastically different to those proving criminal charges beyond all reasonable doubt. Appeal is accordingly disposed with the above terms. Therefore, they have set aside the conviction, but however, the Supreme Court heavily, because they have plenary power, hold that by acquittal of these charges he is not entitled for revisiting of his departmental punishment. So, where so many judgments were discussed, multi-number of paragraphs are there, you can understand what the very main thing. They will say, the crux of the matter, if somebody should be trusted, then that trust is breached, it is breach of trust. Not only for breaching of trust, he appropriate that for wrongful gain or wrongful loss, then he is liable for criminal breach of trust. Same thing 409, because 415 is a definition class for criminal breach of trust. Then step by step aggravated form. Indian Penal Code is chapterized so that aggravated form of offences are step by step named in sections. So then the criminal breach of trust, then criminal breach of trust by servant, then criminal breach of attorney and power of attorney holder and others. Finally, criminal breach of a public servant. Then question arises, that is about 420. 420, deception should be there, parting with the property. This was a simple argument and here elaborately discussed. Then here, this is most important, 477A. Merely falsification of accounts, it should be what they say, mutilated, that destroyed, altered, or falsified the book, electronic paper, etc. So in the absence of that, here he seems to have issued a loose checks enabling the third party to enjoy certain benefits. That benefit either causes loss to the bank or to the any third person. However, this had happened because there was a delinquency of this departmental functioning. Therefore, departmental inquiry was there. He was earlier convicted, earlier dismissed from service. However, since here in Supreme Court, while setting aside the conviction, they hold that this will not entitle the departmental bank official to claim any revisiting of departmental inquiry punishment, and they hold it, they were rightly punished. They put an end to their claim of whatnot. If that punishment is reversed as compulsory retirement or some reduction of pay, he may be getting pension, graduate, probably he would have earned more than that everybody knows about that. See, I am very sorry to say, for the past 3 days I am not well. I am running fever, I am lying on bed, so if any cases are called in my absence, probably all my junior may accurately attend. Suppose if they did not notice, kindly get me an adjournment on behalf of me. That will be my humble request. I will manage today and I will be alright from tomorrow. Today also I am not alright. My heavy body pain and head pain is there. I do not know why this had happened to me. Whatever it may be, human being life, we have to suffer for certain ailment. The ailment, sufferance of ailment is one of the what we say practice of dharma. It's also practice of dharma. You can't avoid sufferings. If you try to enjoy this, not enjoy, tolerate the sufferings, then the next after relieve that sufferings, you will have some more better experience. Behave in the society for others. Best wishes.